The ILO founder recognized in 1919 that the global economy needed clear rules in order to ensure that economic progress would go hand in hand with social justice, prosperity, and peace for all. As a response to this need, the ILO develops international labor standards, which are an expression of universally acknowledged principles and rights at work. The standards, which take the form of conventions or recommendations, provide models for government to draft laws and policies. Some of the major characteristics of international labor standards are their flexibility and universality. They are developed to take into account the diverse cultural and historical backgrounds, legal systems, and levels of economic development in ratifying states. The ILO has standards that look into different areas of labor, including collective bargaining, wages, termination of employment, social security, labor administration, and equality of opportunity and treatment. Courts are increasingly drawing on international labor standards and on the work of the ILO's supervisory bodies to interpret and complement their domestic law.
Under the working conditions aspects, or rather the women workers' rights for which this workshop is being convened, we are trying to look at the international labor standards and the national laws in existence that create an enabling condition for women workers to take part in the world of work. And we have found through our various research and through our discussions with workers and employers in Zimbabwe that there's a gap in terms of understanding that women workers' rights are human rights, and there's a need for us to have recognition of the differences between us as men and women in the workplace. So this workshop seeks to then build your capacity to assist women workers who may come to you requiring support in terms of how they can work more effectively within their various workplaces.
So the significance of this is to ensure that various conventions signed come into life through jurisprudence and daily application by lawyers such as yourselves. We do recognize that you are the people who take these matters to the courts, to the labor court, to the high court. And so once you have consciousness of the international labor standards, and then it becomes possible to bring them to life and to realize these rights, not only for your clients whom you work for, but many of you here I see are senior partners who are employers in your own right. So this should also cascade into a direct benefit for your employment and your workplace policies. Obviously, the greatest focus of this is to recognize that there's a gender mainstreaming, and we are trying as a legal profession not only to be human rights conscious, protectors of human rights, but also protectors of gender rights. And this is one of the most critical aspects of this training.
I want to say in general, regarding the UN and the ILO, that we are here not to replace the role of states. We're here to assist, to bring the tools to that. But we cannot take the place of the states either. But we can mitigate through promoting our work as much as possible. We have a tier structure. We have, first of all, the International Labour Conference. We call it shortly the conference, or the ILC, which meets once a year in Geneva, which is in Switzerland at headquarters, for 2.5 weeks. And it is comparable to a legislative body. It is a conference that adopts the standards. It's composed of all country delegations. And I think we have 187, sorry, I have got hiccups, 187 member countries. So that's quite a lot. And all country delegations meet in Geneva and debate standards to be adopted and adopt the standards. And it also adopts the budget and the program of activity of the office. So we have 2 ILOs. That's very important. We have the International Labour Organization, of which Zimbabwe is part. So it's all the member states. And then we have the International Labour Office, where we work with the secretariat to the organization. So it meets once a year to adopt the biennial budget and biennial program. The delegations, each country has a delegation, and you always say that Djibouti has as many votes as the United States. So each country has a 4-member delegation where each of the 4 delegates have the right to vote. So 2 government representatives, 1 employer representative, and 1 worker representative vote. And then you can have technical advisors. If we had workers represented here, they would immediately raise a hand and say, why only 1 for the union when we have 2 for the government? This is a question that often arises, and 1 for employee. And there are 2 reasons. One, it is, first you can argue that the government has 2 and the social partners together have 2. The other one is when you ratify a convention, the burden of implementing the convention lies upon the government. Financial and implementation. And therefore, the government should really have a strong say in that. That's the reason why. So we distinguish 3 categories of standards. And the first categories concern 8 core conventions, which come under a 1998 Declaration of Fundamental Principles and Rights at Work. This declaration, we adopt very few declarations in the ILO 4 or 5, so it's not a legally obliging text as such that you can enforce, but it has a very strong moral pervasive value. It was adopted given the failure of the WTO, World Trade Organization, to adopt the social clause. Some of you are aware of the debates where the former GATT was becoming a fully fledged organization, because the GATT was only an agreement, fully fledged organization, and there were several countries, including the US and other, and then European countries, who pushed for to include a social clause so that we don't have a wild competition. And then you have some other countries, including developing countries, and in particular India, who said this is a new form of protectionism. And finally, the social clause debates did not work out in the WTO, but it was brought back to the ILO, and therefore the ILO adopted this declaration, which means that there are certain basic conventions, basic human rights, every country, by virtue of being a member of the ILO, should ratify. If you need 2 words for the ILO mandate, it's social justice. The main instrument for that is international labor standards. And international labor standards are I don't find my word, but they are throughout, cross-cutting in the office, and they are the basis for a lot of technical programs we have. Like employment creation are based on conventions. Programs on HIV/AIDS are based on Convention 111 and the recommendation on HIV/AIDS, etc. So we do have, and there we do not have regional standards. And that's a bit what I was looking for as a comment. So we have, and somebody in the expectations was, how do we have one coherent interpretation of standards throughout the world? And that is through the ILO supervisory bodies. I don't know if it was you who mentioned that or not, but somebody was talking about that. So why would you promote regional or national standards? The ILO philosophy is based on a sentence called, it's often widely quoted, that you cannot have substandards for subhuman beings, isn't it? Should I, because I'm a Swede, have better standards than you? No, we're all equals in terms of human dignity. So we all should have the same entitlements. However, when it comes to measuring them in economic terms and social terms, there is a recognition that we have, as you're very correctly putting it, reached different levels. And therefore, we have devised what we call flexibility clauses in certain conventions. Like the Social Security Convention 102, which is the basic instrument, has 9 different parts. And when a country ratifies, it can choose to not ratify all 9 parts, but leave it to a later stage to ratify the rest of the parts. Or, for example, the Convention on Minimum Age, the Child Labor Convention. The basic philosophy of that convention is to ensure that children go to school. So the minimum age that has been fixed is 15. Some countries go beyond this, they put 16 or 17, but the flexibility is always specified in the convention. Zimbabwe cannot ratify a convention and say, oh, we'll invent our own flexibility. That's not the line, but there are flexibility. Standard setting is not reserved for a club of European nations, etc. It's not. It is something that has been there since 1990. Of course, you became independent more or less late, and Zimbabwe more late than many others. So you came in the game when many standards had been set up, but you have ratified them. There is a mechanism to adopt standards where all countries, the governments in particular, should have the possibility to and should be actively encouraged to participate in, to make sure that your concerns are in there. But a number of times we hear complaints by governments, oh, but your standards is for the rich countries, but don't participate. And that is really, is very sad. I mean, sad. It's deplorable. Because the possibility is there. Since 1990 up to now, Zimbabwe, I think, is active in this regard. But you need to have a more proactive from all developing nations.